Joining us now, conservative attorney and Lincoln Project co-founder George Conway. George, I want to get your reaction in just a moment, but first, we just heard how the former president apparently reacted to today's proceedings. I mean, he was the one, I guess, to replace the legal team just days ago. Does that reaction surprise you?
No, it doesn't. I mean, one of the things I tweeted during these proceedings was there's going to be one guy in Palm Beach, Florida, who's going to be very, very unhappy at what he was seeing, particularly Mr. Castor, who had nothing to say that was coherent and was saying it in almost a somnambulant way. There was nothing in there that was either compelling from a legal standpoint, and importantly for a former president, engaging from a televisual standpoint. So he was never going to like that, and the reporting that we've just heard is not surprising at all.
Is it just that he can't attract decent, great lawyers, that he doesn't pay them? Or...
He can't. He always had trouble attracting great lawyers. In 2017, in fact, he consulted with me on this. He was asking around to find a good, top-notch law firm to represent him in the Mueller investigation, and he couldn't find one. That's how he ended up with Jim Dowd, a solo practitioner. He cannot. And it's gotten worse since then. Yeah. I mean, not even the people who represented him in the 2019-2020 impeachment are willing to help him now. And it's a really extraordinary thing. I mean, this man is supposedly and probably worth a couple $2 billion. He's a former president of the United States. And this is the best he can do in terms of lawyering. These guys were terrible. In 30 years, I practiced law for 30 years. I've seen good lawyering and I've seen bad lawyering. I have never seen such an extreme juxtaposition of good lawyering and bad lawyering in one proceeding at one time. And these guys were just absolutely awful. Now, you can cut them a break because they were only called into the case a few days ago, but still, I mean, there are law review articles that explain the arguments that they could make. They distorted one of them, a professor who wrote a law review article that laid out both sides, took the other side from them, but it laid out exactly the arguments they needed to make. They didn't even do that. The first presenter didn't even touch the argument.
What do you think was the first, Castor, what do you think was his strategy? I mean, there must have been some sort of thought process. To me, it was like a meandering drunk wedding speech, but there must have been some reason behind the, ridiculous flattery of the senators. And it just, I don't know. Do you think there was, or was he just trying to distance himself from the emotion of Raskin?
I have no idea what that. I mean, he had a yellow pad where he had notes, so it was thought out to some degree. What he was trying to accomplish was absolutely beyond me. It was disorganized. It was rambling. It didn't touch upon the issues that were facing the court of impeachment. It was mystifying what he was doing.
And yet,
I just don't get it.
And yet, only one Republican senator seemed to be convinced from a previous vote he had that this should go forward. What does that say? That the president's attorneys can put on a terrible display and doesn't, only one person.
It's shameful. It is absolutely shameful because the fact, this was bad lawyering. This was ill preparation. But the fact of the matter is, the fundamental problem they had is they didn't have an answer to. This should have been their best day, actually, because this is, the case. There at least is an articulable case against trying a former public official. It's not a good one, but at least there is a coherent argument to be made, and some people have made it. There's no coherent argument to be made about whether the president of the United States has a First Amendment right to encourage people to basically end American democracy by stopping a count of the electoral votes. And on the merits, on the facts, as that video powerfully showed, they're dead to rights. This should have been Trump's best day.
This was the
and it
easier
was in
day
the
for
sense
them.
that they got 44 votes. But that is just shameful that 44 senators could look and watch that for 4+ hours and not do the right thing.
The argument I thought of what Representative Raskin called a January exemption, I thought was an interesting argument that a president can be impeached all the way up until an election, and then suddenly, if you believe that he can't be impeached as a former president, a future president could just do whatever they want in the month of January. Did you buy that argument?
Oh, absolutely. It's a powerful argument. They referred to the so-called January exception in their briefs, and there's a lesson there for lawyers. And one of the things I first learned when I began practicing law from more senior lawyers is that whenever you get a chance to appear before a judge before a trial, whether it's on a matter of jurisdiction or a matter of discovery or even just a scheduling conference, you want to preview your case before the judge to get the judge thinking, hey, these guys seem like they have something, that they're right. And here's what the House impeachment managers brilliantly did. When you're making a legal argument of any sort, where you're trying to persuade the court that X is the correct rule of law, you basically do three things in this order. One is you show that the text of whatever it is you're interpreting says X. The second thing you do is you show that historically people understood that the text meant X. And the third thing you do, and the last thing you do is, and X makes a lot of sense. How could the rule be anything other than X like we've shown you? What they did here is they took that last point that you normally make in a brief and they put it front and center, which is this has to be the rule. There cannot be a January exception to a president's constitutional oath of office to preserve, protect, and defend the Constitution of the United States. It cannot be that in his last days of office, there's a January exception that where he can basically do whatever he wants, including subvert democracy to stay in power and not be subject to impeachment and a future punishment such as disqualification. And that's how they made that movie relevant. That's how the video relevant, and that's how they brought in the emotional points that Representative Raskin made in the closing portion of the argument. It was just brilliantly done. And again, in 30 years, I've never seen such good lawyering juxtaposed with such bad lawyering in one place at one time.
You know, it's interesting, just in your description of it, now I get why it was so effective, because watching it, when he showed the calendar with all the years blocked off except that 1 month, it frames the entire thing. And it made the video then even more powerful and sort of it gave you an intellectual basis behind it.
And it set up the textual argument and set up in particular the historical argument, because in 1787, they explained there was a fellow named Warren Hastings who was Governor General, the King's Governor General in India, and he was impeached and tried after he had come back to Britain. And then the 1876 precedent of Secretary of War William Belknap, who resigned hours before he was impeached, and he was tried, and the Senate voted that it had jurisdiction by 37 to 29. Of course, the Trump lawyers had basically nothing to say about that.
In fact, what they did have to say, which I just thought was so, I don't know, I'm no lawyer, but I do know, British common law, American law is sort of based on what happened before. And that was one of the first things that the first attorney said is, why are they even talking about, we don't want a king here, which is just sort of, just ridiculous.
The reason why it's relevant is the Constitution talks about impeachment in basically 3 or 4 very short sentences. And the reason why it doesn't put forth like 2 pages about impeachment is the framers were relying on English parliamentary history. They knew what impeachment was, and they changed it in a couple of ways. They limited the punishments for a conviction to removal from office and disqualification from further office. In England, you could actually put somebody in jail, but other than that, they left it unchanged, and that's why it was relevant.
George Conway, thank you. Always appreciate it.